Welcome to WT Safety Compliance Consultants. My name is Vladimir, and I'm assuming if you've clicked on this link that you are appointed as a Section 16.2 or will be appointed as a Section 16.2, and you're not quite sure what your responsibilities or liabilities are in terms of this appointment and the Occupational Health and Safety Act. So before I can explain to you exactly what your responsibilities and duties are, I'd like to refer you back to the definitions within the Occupational Health and Safety Act of an employer. So I'm going to quickly read that definition through to you. An employer means subject to the provisions of subsection 2, any person who employs or provides work for any person and remunerates that person or expressly or tactically undertakes to remunerate him but excludes a labour broker as defined in subsection 1 of the Labour Relations Act 1956, Act 28 of 1956. So if you're appointed as a Section 16.2, obviously you're already considered to be an employer, or your employer is considered to be an employer, and you're representing the employer. So let's quickly read what the Occupational Health and Safety Act says in Section 16.2. But before I do that, I'm going to read the whole of Section 16.1 before I jump onto Section 16.2. So here we go. OSH Act Section 16. This is an extraction from the Occupational Health and Safety Act. Every chief executive officer shall, as far as is reasonably practicable, ensure that the duties of his employer, as contemplated in this act, are properly discharged. Now I'm going to give you more details with regards to what the responsibilities of the employer is. But let's jump onto the most important section, and that's why you're viewing this video. It's Section 16.2, the site agent. Without derogating from his responsibility or liability in terms of subsection 1, a chief executive officer may assign any duty contemplated in this subsection to any person under his control, which person shall act subject to the control and direction of the chief executive officer. So you are basically considered to take on the responsibilities of the employer in terms of the Occupational Health and Safety Act, or any other responsibilities that is assigned in that specific appointment. So now you are wondering, what are the employer entailed to do in terms of the Occupational Health and Safety Act? Well, the Act specifies it very, or summarizes it in subsection 8 of the Occupational Health and Safety Act. I'm going to read some parts of the Occupational Health and Safety Act, Section 8, the general duties of employers to their employees. So this is just a summary. The construction regulations and the general safety regulations and the hazardous chemical regulations will add on to the responsibilities, but this is a good summary to work with. So it has got a bit of listening work, so please take the time, because it's very important that you know exactly what the responsibilities of an employer is, which ultimately is what your responsibilities is as a appointed Section 2. Every employer shall provide and maintain, as far as is reasonably practical, a working environment that is safe and without risk to the health of his employees. So that seems fairly simple, but as we delve a little bit more into this section, you'll notice that it does become quite a bit onerous. Without derogating from the generality of an employer's duties under subsection 1, the matters to which those duties refer to in particular include the following. And here's where it gets a bit more tricky. The provision and maintenance of systems of work, plant and machinery that, as far as is reasonably practical, are safe and without risk to the health. So let's look at the words here, the most important words: the maintenance of systems of work, plant and machinery. So if you, for instance, have a generator that you have, then you need to ensure that that generator is maintained and the systems of work within that generator is maintained, and that they are as safe as reasonably practicable to the employees or to the health of the employees. So if there's a leakage of diesel or petrol on a generator, then you'd ultimately need to say that that generator is not maintained and there's exposure to the health of the employees. Alright, so taking such steps as may be reasonably practical to eliminate or mitigate any hazard or potential hazard to the safety or health of employees before resorting to personal protective equipment. So what are we looking at now here? The most important words are eliminating or mitigating any hazards or potential hazard. So this is normally done by means of a risk assessment. So you'll evaluate or you'll identify the hazards first of all, and then you'll evaluate it by means of a risk assessment to eliminate it if possible, that specific hazard or risk, and then or to mitigate it, to make the risk less in terms of the scope of work that needs to be performed. So further on to that, let's quickly look at the next point here. Making arrangements for ensuring that as far as is reasonably practicable, the safety and absence of risk to the health in connection with the production, processing, use, storage, or transport of articles and substances. So the important words here are ensuring that there's safety or the absence of risk to the health in connection with the production. So you need to ensure that the safety of employees are a top priority in terms of the production that is done on a daily basis. And here comes the big blow in terms of the responsibility of the employers, and I need to read this out, and you need to listen and understand. I'll discuss this afterwards. Establishing as far as is reasonably practicable what hazards to the health or safety of persons are attached to any work which is performed, any article or substance which is produced, processed, used, handled, stored, or transported, and any plant or machinery which is used in his business, and he shall, as far as is reasonably practicable, further establish what precautionary measures should be taken with respect to such work, article, substance, plant, or machinery in order to protect the health and safety of persons, and he shall provide the necessary means to apply such precautionary measures. So, once again, a lot to take in. What we would be looking at here is the hazards to health and safety attached to any work that is performed. So, you need to basically look at your process, your systems of work, and then identify the hazards as I've mentioned earlier on, and then evaluate those hazards in a risk assessment, and then identify safe work procedures and ensure that those safe work procedures are followed, and that those safe work procedures are communicated to your employees. So that is quite a bit to take in. Um, let's move on to part 4 of the Occupational Health and Safety Section 8, providing such information, instruction, training and supervision as may be necessary to ensure, as far as is reasonably practical, the health and safety at work of his employees. And like I've mentioned before, you've now done a risk assessment, and you've evaluated all the risks, and you've identified the hazards, and you've created safe work procedures. Now you've informed the employees of all of the above, which is the information, and you've instructed them how to do their work safely. And you've trained them on how to do it safely, but now you need to make sure that it is supervised, because you cannot be all at all the places at the same time. So you appoint what is called a construction supervisor in the construction regulation. In terms of construction regulations, appoint a construction regulation 8.7 appointment to construction supervisor. But you can't appoint a one construction supervisor, to supervise 15 employees which work in different locations. So ultimately, you'll need to appoint more than one construction supervisor, which is your construction supervisor 8.8, to ensure that the work is supervised accurately. Further on, let's just look at that. As far as is reasonably practicable, not permitting the employee to do any work or produce, process, use, handle, store, or transport any article or substance, or to operate any plant or machinery unless the precautionary measures contemplated in paragraphs B and D or any other precaution measures which may be prescribed have been taken. Basically, all this states is that you cannot ask an employee to do an unsafe act, because ultimately you'll be asking that employee to commit suicide, basically, if that's the case, to that extent, if that's the case. Um, but yes, so it is quite onerous. Uh, Here's the last section, part of the section 8, which summarizes what we've just been speaking about. Taking all necessary measures to ensure that tire requirements of the Act are complied with by every person in his employment or on premises under his control where plant or machinery is used. So here's the section point 2. You need to ensure that you comply, and this is normally done by means of an audit, occupational health and safety audit by a consultant or internal audit for that matter. So you need to identify where there is possible deviations and act on those deviations. And I'll read on to exactly why I'm saying act on the deviations. Ensure enforcing such measures as may be necessary in the interest of health and safety. So if you see that any employee acts unsafely, then you need to take action upon that. You can't assume that it's negligence on behalf of the employee and you've done your part and he hasn't done his part, so ultimately he's responsible for it. It doesn't work that way. You need to show that you've taken steps to ensure that health and safety is adhered to at all times by giving written warnings or NCR non-compliance reports. In short, ensuring that work is performed and that plant or machinery is used under the general supervision of a person trained to understand the hazards associated with it and who have the authority to ensure that the precautionary measures taken by the employer are implemented. So that would generally be your safety officer or safety rep or construction supervisor that are aware of all the safe work procedures done. That's basically that in a nutshell. The employer's responsibilities towards the Occupational Health and Safety Act. And what I'd like to do with this video is to indicate to any appointed 16.2 or to be appointed 16.2 appointment that they are aware that they take on the responsibilities of an employer on site, and that it's just not a document that is signed and placed in a file and forgotten about. If worst comes to worst, that appointment is the first appointment that will be looked at, and the responsibilities in terms of the employer will be matched up against that appointment, and ultimately if it doesn't correlate, then the 16.2 is liable to an extent for whatever went wrong in terms of a particular incident. So hopefully this has been informative. If you have any questions, please do give me a call on 071 178 4428 or drop me an email on werner@wtsafety.co.za. And thank you for your time, and hopefully I'll see you soon. Goodbye.